Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about fresh evidence and hearsay. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Downey was charged with his involvement in a murder and alleged to have transported a body to a graveyard. After his trial had been completed and he was convicted, information came to light that a third party had made an inculpatory statement essentially confessing to the action that Mr. Downey had been convicted of being involved in. As a result, Mr. Downey applied on appeal for the court to admit fresh evidence related to this out-of-court statement and raise the possibility of a third-party suspect. The Court of Appeal had to consider whether this was fresh evidence, whether this was a third-party suspect, or whether this was just an application to admit hearsay evidence that didn't have significant evidentiary value, and they ruled against Mr. Downey. But this case raises very important issues because statements and confessions can often come after a trial is completed and can play a significant role in determining whether or not there has been a miscarriage of justice or an improper conviction. These statements need to be treated very importantly. Mr. Downey was essentially arguing that the Supreme Court of Canada should take this case to try and develop a distinction as between the admission of fresh evidence and the admission of fresh evidence as it relates to a third-party suspect. And that there should be some distinction between these two concepts because of the way that the trials proceed and the evidence is heard. Third-party evidence is a much lower bar to raise in a criminal trial than fresh evidence on appeal. So the bar should be lower when it comes to a third-party suspect and the fresh evidence application being brought after trial. The Supreme Court of Canada had the important opportunity to deal with this issue and potentially create a new legal test that could prevent wrongful convictions. It obviously makes sense that confessions from third parties are going to come after somebody's been convicted because sort of the heat is off at that point. So shouldn't that type of evidence be more easily and readily admissible in an appeal hearing than it would otherwise be the other types of fresh evidence that could be heard? Unfortunately, the Supreme Court of Canada declined to decide this issue, which means that we're going to have to wait for another case in which this distinction may arise and in which somebody may have been wrongfully convicted before we can actually see whether or not there should be a distinction in law. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazenable Creative for putting together these videos. Please like, subscribe, and share with your friends.